Yes, ground two.
Yeah. Yes, ground two, my lord. And it won't surprise you to know that we start by saying that the judge was right to reject the argument that's at the heart of ground two, for the reasons he gives at paragraphs 152 to 155 of the judgment, paragraphs 247 to 248 and 327. We also set out the reasons why this ground should be rejected in paragraph 76 and following of our skeleton argument, which you have it in the core bundle at tab 2, page 99. And we say that in relation to ground 2, the position is neatly summarised by Farwell at page 307, tab 19, page 386 in the authorities bundle. And he makes the point very neatly that where you have a change in visual aspect over time, for example, after a turn, which is what happened in this case, that does not affect the application of Rule 14b, sorry, Rule 14, if on initial sighting.
Where are you reading from on 386?
On 386, my lord, by the passage that is the middle passage beginning as vessels on parallel, paragraph beginning on as vessels on parallel but slightly offset courses draw closer. And then if you go about half to 2/3 through the paragraph, there's a sentence beginning such a change.
Yeah. Does not affect the application of 14.
And that, my lord, is for the very simple reason that there is a continuing risk of collision. In this case, it's been found as a fact that it arose at C minus 22. And you cannot suggest, it makes no logical sense to suggest that because one vessel takes action to avoid a risk of collision, that manoeuvre, even if it's a late manoeuvre, alters the application of the rules. And indeed, that argument, which is effectively what my learned friend is submitting, would be inconsistent with the situation, with Rule 8D. And my lords, can I just take you to that? And you have that again in the authorities bundle, tab 13, page 200. I'm sorry, I was about to go to the convention. It probably make more sense to go to the statutory instrument, which is the supplementary authorities bundle, tab 2, page 21.
Yep.
Action taken to avoid collision with another vessel shall be such as to result in passing at a safe distance. The effectiveness of the action shall be carefully checked until the other vessel is finally passed and clear. And again, my lords, that is, we say, strong support for the position that if at C minus 22 there is a risk of collision which results in a head-on situation, that head-on situation does not end until both vessels are safely clear of each other. And just to be clear, we're not arguing for an indefinite application of Rule 14. We say the obligations under Rule 14 end once the vessels are safely passed and clear, which on any view of the facts in this case, at C minus 745, they were not. Now, my learned friend had a point in argument yesterday. Well, the vessels were passing each other, and it was only the turn to starboard which created the situation, the the risk of collision. That point fails, quite frankly, simply because the court has already found below, quite rightly, that there was an ongoing risk of collision. And it cannot be the case that if one vessel takes action to avoid a collision, even if late, that justifies the other vessel acting improperly. And it certainly cannot justify the turn to port that was later subsequently made in this case. And I remind you that shortly before C-745, the KIVELI had made two small alterations of port. The effect of those alterations to port was to put the vessels on an even more closely reciprocal course. So it's difficult to comprehend on what basis my learned friend says a head-on situation had ceased to exist by C-7. We say that the appellant's arguments, were they to be successful, would put Rule 14 in a different position to Rules 13 and Rules 15. And I'm conscious that Rule 13 has an express provision in this regard, that Rule 13D. Which you can see at page 24 in the Supplementary Authorities Manual. But that is simply an expression of the principle outlined in Rule 8D, that vessels should treat that if there is a risk of collision, the situation the vessels find themselves in continues until the risk of collision is past. And likewise in the Orduna at in the House of Lords, the position that the House of Lords emphasised also that a similar position should apply in relation to Rule 15, which of course does not have any express provision. Now, a point was taken about the scope of what Lord Finlay was saying in the Orduna. And can we just briefly turn that up? It's in the Authorities Bundle, tab 1. And your lords will see the text, your lordships will see the text sidelined in red starting on page 4. And the relevant passage is at the top of page 5. And you'll see, my lords, that what Lord Finlay says, the conditions which render the regulations for crossing ships applicable begin as soon as the two ships are approaching one another on courses which, if continued, may cause a collision. These conditions continue to subsist until the vessels have definitely passed out of the phase of crossing ships. Now, my learned friend wishes to say that that's simply a reference to the courses thereof. What it is quite clearly a reference to is crossing ships within the meaning of the rules. And crossing ships within the meaning of the rules refers to ships that are crossing, such as to create a risk of collision. Now, Lord Finlay is quite clearly envisaging that Rule 15 will continue to apply until the risk of collision has passed. And we say that the conclusion that the judge reached in this case is also consistent with the position emphasised by the Supreme Court in the Ever Smart as to the structure of Rules 13, 14 and 15, namely that they provide a comprehensive code for dealing with the risk of collision between vessels that are in sight of each other, and that rules 13 and 14 take precedence over rule 15. Now, my learned friend's argument was also rejected, again by the US courts, in the case of Gulf Coast and MT Anco Princess. And can I just take you to that, my lords? You have it in the bundle of authorities at tab 14, page 268. My learned friend briefly outlined the facts to you yesterday, so I wasn't going to repeat them. But can I take you to page 272? And the Court of Appeal on the left-hand side, the left-hand column, about halfway down the middle paragraph, says this: once Article 18 comes into play, a vessel cannot change what is an end-on situation to one which requires a starboard-to-starboard passage. So, my lord, we say again that that is another pointer to the fact that once a risk of collision has arisen, as it did here at C-22, if your lordships accept that the judge was right to conclude that it was a head-on or nearly head-on situation, that does not change as a consequence of our turn to starboard. And this is not us trying to take advantage of a late manoeuvre. This is us complying, albeit late, with our obligations under Rule 14. And your lordships contest the merits of my learned friend's arguments on ground 2 by his submissions as to what is the consequence of the head-on situation coming to an end, because he's not arguing for a Rule 15 that matter it became a crossing situation. In fact, it's not entirely clear what he says the situation should properly be characterised if it is no longer a head-on situation. And as I've already pointed out, as the lordships made clear in the Ever Smart, it can only be one of 3 things: head-on, overtaking, or crossing. It's not a crossing situation, on my learned friend's analysis. It's not an overtaking situation. It must remain a head-on situation. And his client, the AFINA and the KIVELI, was obliged and remained obliged to turn to starboard, not to turn to port. So, my lord, unless I can help you any further on ground 2, I was going to move on to apportionment.
Yeah.
My submission is obviously that ground 2 should be rejected.
Yeah.
Now, apportionment only becomes an issue, obviously, if the appellants succeed on either grounds 1 and 3 or ground 2. We do maintain our position that no permission to appeal has been granted on apportionment, or no permission to appeal on apportionment if there was a crossing situation has been obtained. Now, I fully accept the position that nobody came here to argue about academic points, but that doesn't deprive from the force of the submission that nowhere in the grounds of appeal or in the applicant skeleton for permission is there an express request for permission to appeal on the basis that the judge improperly applied the test for apportionment if there was a crossing situation. And we say it isn't enough to say, well, Lord Justice Popplewell said that if permission was granted on grounds 1 and 2 that might affect apportionment. That is not a grant of permission to appeal on apportionment, nor is it enough to say, well, our ground 3 in the notice of appeal sought permission to appeal if, because the judge should have assessed matters on the basis that it was a crossing situation. Because if one looks at the judgment, it is quite clear that the judge did assess apportionment, did assess liability, if he was wrong on the question of whether it was rules 14 or 15 which applied. And we say that if you look at the question of KIVELI's fault, and indeed AFINA I's fault, if there was a crossing situation, that is expressly addressed by the judge. Can I give you some paragraph references in the judgment? Paragraphs 250, 253, 254, 255, 262, 289, 315 and 316. He also, in his discussion of apportionment at paragraphs 326 to 331, took KIVELI's fault into account on the basis that either there was a crossing situation or there was a head-on situation. And he did confirm that in the consequentials judgment of paragraphs 8, subparagraph 2, paragraph 11, subparagraph 2, paragraphs 14 and 22. And if there was any doubt about the fact following his original judgment, you are entitled to look at his second judgment for confirmation that that was what he did.
Does the percentage on this hypothesis emerge before the consequentials judgment?
The 80...
That it would still be 80-20 in a crossing situation, is that clearly stated in the judgment, or is that?
It's stated in the, we say it's stated in the judgment, my lord. When you read his judgment as a whole, it's very clear that he was apportioning liability on the basis of 80-20, irrespective of his findings on Rule 14 or Rule 15, given his, what I would like to call, holistic approach to the application of the rules in general.
If we look at the facts recited by the judge in advance of that 80-20, some of them at least chime more readily with the Rule 14 analysis than the Rule 15 to 17 analysis. That's what made me wonder whether the judgment is as clear as the consequentials undoubtedly are.
Oh, my lord, I don't think I can depart. I have to accept that there are passages in his judgment that, as your lordship put it, chime more readily with a Rule 14 rather than a Rule 15 analysis. But it is clear that when one looks at the judgment, he had in mind that he might be wrong on Rule 14, Rule 15, and that he had approached the question of apportionment taking into account that fact. And just to give you one paragraph to that effect, my lord, if one looks at paragraph 289 in the judgment,
Look at 326. The judge comes to apply the principles on page 240. And, significantly invokes the Rule 14 failings.
well, as I said, my lord, I don't seek to persuade your lordship that there are elements of the judgment that chime more readily with a Rule 14 rather than a Rule 15.
Is there any reference to Rules 15 to 17 in paras 326 to 331 when the judge derives the 80-20 apportionment? Yes, there is, 327. So it is
well,
there.
my lord, paragraph 327. and 328. My lord, I do emphasise that those paragraphs where he deals with apportionment, 326 and following, have to be read against his analysis of causation earlier in the judgment. And you have, for example, paragraph 289, where he expressly deals with what he considers to be the breaches of Rule 2 by KIVELI, if he is on the basis that he is wrong that there was a head-on situation.
And if it's a crossing situation, do you accept one's got to do two things? One's got to look at the AFINA I fault in the light of what it would have been obliged to do in that situation and what it did, which may involve different questions to Rule 14. And then the same for the KIVELI as well. So it changes the entry point, as it were, for assessing fault for both vessels, doesn't it?
Well, you still have to assess fault for both vessels, whether it's Rule 14 or Rule 30. Sorry, Rule 15, because in Rule 14, they're both obliged to turn to starboard. Under Rule 15, one is the stand-on vessel, one is the give-way vessel, and each has different obligations. So I accept it changes the potential starting point for the analysis under those rules. What it doesn't change is the analysis under Rules 2, 5, 7, 8 and 34, 36. And your lordships will have in mind the very strong reasons why, even if it was a crossing situation, the judge concluded that the root cause of this collision were the failings on board the KIVELI, going back to the decision of the master to stand down the lookout in circumstances where the vessel was entering a seaway where there would be other vessels heading for a strait. And there is no challenge to the fact that that is material the judge was entitled to take into account for the purposes of apportionment. Likewise, my lord, the evidence that the officer of the watch on the KIVELI was navigating deliberately in breach of the collision regulations, was navigating deliberately in breach of the standing orders on board his own vessel. And that on two occasions, more than two occasions, he did the one thing that you're not supposed to do, whether it's irrespective of whether it is a a crossing situation or a head-on situation. Namely, first of all, nibble to port on two occasions, and then secondly, turn dramatically hard to port in circumstances where you have already seen that the other vessel has turned to starboard. Now, I don't want to revisit all the facts that the judge took into account, because I'd say that's not for this court, but the failings on the part of the KIVELI in this occasion, in this action, stand out as remarkably egregious. This was a vessel that did not have an effective lookout throughout the officer of the watch's watch. So, but my lord, that's kind of that has slightly trespassed into the grounds of what happens, and there is an overlap. If this court were minded to revisit apportionment, as I said, we say first of all, there's no permission to appeal the apportionment. But even if we're wrong about that, we say it's only in exceptional circumstances that the court should interfere with the judge's allocation of blame. And I don't think there's any, I think there's no dispute between us about that principle, as I understand it. But should you need the references, my lords, it's the Königin Juliana at pages 115 to 116 in the report. But in the authorities bundle, tab 3, page 17, and the 16th edition of Marsden, paragraph 10, dash 11, at paragraph at authorities bundle tab 21, page 422. And we've also set out the relevant references in our skeleton argument at paragraph 83, which is at tab 2 in the core bundle, page 101. And we say,
So those are references specifically to apportionment.
yes, my lord.
Yeah.
Particularly the passages on page 17 and 18 from the judgment in the Königin Juliana.
Yeah.
I was wondering, is there any difference between land rats and water rats here? Is it essentially an example of the general principle about interfering with the trial judge's evaluative findings one sees in all civil litigation, which is that the threshold is very high?
Save only this, my lord. It is very high, but the authorities do, in the context of collision actions, put the test as exceptional. And that is the test which should apply. And it's exceptional for good reason, which is that the trial judge, as with a judge in a road traffic accident or whatever it may be, has heard the relevant factual evidence, has heard the expert witnesses, but in this case, but in collision actions, has had the benefit of the advice of the assessors, and has also had detailed evidence as to the navigation of both vessels. And of course, your lordships have, over the course of 2 days, heard argument that has principally gone to questions of construction. Mr. Justice Bryan also had, in the course of the 3 days in front of him, detailed references to, detailed analysis of not only the agreed animated plot, but also flipbooks of the radar printouts, printouts from the ECDIS screen on board the KIVELI, and had the benefit of hearing the officer of the watch on KIVELI give his evidence live. And you will see from the judgment the significance that that evidence had in the formulation of his views on apportionment. So, of course, that doesn't affect the nature of the test that your lordships have to apply, but it does help illustrate why, at least in the context of collision actions, the test is put at the level of exceptional.
I see that Lord Edmund Davis, one of his justifications for not getting involved in this sort of thing is that he thought that the appellate tribunal was more blessed with logical analysis than a first instance judge. I'm going to say, I'm not entirely sure that one would go along with that.
Well, my lord, I'm not sure that...
But he offers it. He offers that view, I noticed, with some diffidence. Yeah, well, we have that point.
You have that point. And my lord, we say that, leaving aside the high level of the test, as the submissions of Mr. Carruth yesterday highlighted, there are obvious difficulties for this court in seeking to go behind the judge's apportionment when there's no good basis to disturb his findings of fact. You're essentially being asked to do a desktop survey or a paper exercise of reviewing the judge's apportionment in circumstances where you haven't had the benefit of the factual evidence that he had. And so we say that is another reason why you should not disturb the apportionment. Sorry, just a moment, my lord. So, my lord, that deals with the question of whether or not you should revisit the question of apportionment. There are two further points, which is if you decide that the judge's apportionment should be disturbed, who should do that? Should it be your lordships, or should the case be remitted back to the trial judge at first instance, Mr. Justice Bryan? We have found that neither of the two authorities that my learned friend mentioned to you yesterday, the Novich-Sach, which is 1977, 2 Lloyd's Report, page 91, or the Coulson-Inge, 1996, 2 Lloyd's Reps, 124, contain any guidance as to the principle of whether or not this court should remit. There's certainly nothing in either authority that suggests that there's any reason why the court should not. And we would suggest that that there's a matter for this court in the exercise of its discretion as to which is the best course you think, can deal with apportionment if you believe it should be reopened. I do note that certainly, bearing in mind what my learned friend said about a convention, that there is no guidance given to the court as to level of apportionment, that in the Novich-Sach, counsel for the appellant, then Mr. Barry Sheen QC, a very experienced Admiralty practitioner, certainly did offer the court guidance as to apportionment, which the court then accepted. Alternatively, that then leads to the question as to if you're against me on every stage, what should you do if you decide to revisit apportionment and apply your own percentages? And we say that for the reasons the judge gives, irrespective of your conclusions on Rule 14 and Rule 15, your lordships can say that he even if you are revisiting apportionment, his assessment of percentage is right, and it should be 80-20. Or if you feel that considering the matter in the round, that there should be a different apportionment on the basis that it was there was a breach of Rule 15 rather than Rule 14. The apportionment should still be an apportionment very largely in AFINA I's favour, because notwithstanding that in a Rule 15 situation, she would have been the stand-on vessel, it was very much the failures of the KIVELI, all identified by the judge, which created the situation that led to the collision. And my learned friend has had to accept that if KIVELI had complied with her obligations on Rule 15 as a Rule 15 stand-on vessel, then there would have been no collision. And had she taken avoiding action by turning to starboard, there would have been no collision. And when one combines that together with all the other failings, that still speaks to an apportionment of liability that places the majority of the blame for the collision, certainly well in excess of 60 or 70%, on KIVELI.
Do we have an indication of how much quantum is involved?
My lord, I'm told this is a very rough figure, but this is on instruction without any evidence to back it up, that there's about 20 million at stake. I don't know if that agrees. On each side, 20 million. My lord, can I for the moment just put it this way? I understand it's in excess of 20 million.
So even a variation of a few percentage, 10%, makes it a difference.
Well, my lord, one might think that's why we're here in some ways.
Not always the case.
Yes, my lord, a change in the percentage by a few percent does have a significant impact if one gets to the question of apportionment. My lord, just very briefly dealing with a few matters that are identified by my learned friend in their friends in their skeleton.
What shall I head this? MISC?
My lord, no, this is dealing with apportionment.
Sorry, we're still on.
Still on apportionment.
We're still on
And why
fine.
they say you should adjust the apportionment should your lordships get to that stage.
Yeah.
In paragraph 69.2, they say it was our fault that caused the close quarters situation. We say that runs contrary to the judge's findings and should be rejected. The judge is quite clear that the root cause of this collision is the navigation of the KIVELI, and in particular her late turn to port. Paragraph 69.4, which complains about our turn to starboard. Again, we say this is an attempt to reopen the judge's findings of fact, but in any event, the judge has found that the officer of the watch of KIVELI saw our turn to starboard, and therefore, having seen that turn to starboard, he should have taken action at that time, not to turn to port, but to turn away. There's also an attempt to submit that KIVELI was maintaining a proper lookout. And again, we say that simply cannot stand in light of the findings of the egregious failure of Mr. Ajida's lookout of paragraphs 23 and following of the judgment, as well as paragraph 292. Equally, to the extent it's suggested that KIVELI's minor alterations of port did not increase the risk of collision, that should be rejected. It brought the vessels closer into a head-on situation. And the advice from the nautical assessor was very clearly that those nibbles to port should not have been made. And the last-minute turn to port. A last-minute turn to port made after the officer of the watch on the KIVELI had not seen our oldest lamp signals and had not responded to our first radio call, that was a breach of the rules. It's a breach of the rule of good seamanship. It's a breach, we say, of Rule 17.2. He'd seen the turn to starboard, and the one thing he shouldn't have done but did do is turn to port. So we say overall, none of them.
Some authority that mariners shouldn't rely on radio communications to decide what to do, but should apply the rules.
There is authority to that effect, my lord. There's certainly a judgment of Mr. Justice Steele, as he was, to that effect. But that's not to say that one can't use VHF if all other means of communication don't succeed. I think that's a fair summary of the position, but no doubt my learned friend will tell me if I've got it wrong, or tell you if I've got it wrong. And then just very briefly, apportionment on ground 2, which obviously is separate, might be separate from grounds 1 and 3. We say that doesn't, even if my learned friend is successful on ground 2, that doesn't affect all the reasons that the judge found for concluding that KIVELI was at fault and to an extent of 80-20. And for all the reasons I've given in relation to grounds 1 and 3. You say you either don't disturb the apportionment or you only adjust it marginally. My lord, those are my submissions. Unless I can help you with anything further.
I've got one point, Mr. Cooper, which is this. Mr. Smith, or the appellants, sent through the proposed questions for the assessors, albeit that part one was part one of the questions that are based on the apportionment dispute, and part two are caveated properly with the submission that it's not a matter for the assessors, it's a matter for the court because they're points of construction. What do you say? Do you have? I'm afraid I've not checked my emails over lunchtime, so I don't know if there's been anything else. But have you got any proposed questions?
Well, my lord, this exercise has felt a little bit, in some ways, like being heading down the rabbit hole, in the sense that I agree with my learned friend that so far as the part two questions are concerned, they're inappropriate because they go to matters of construction.
Yeah.
So to that extent, although the wording is a wording that my learned friend and I had discussed and had come to a landing on, we are both saying to the court that you should not ask the questions in part one.
Fine, that's just confirmation of what I thought, but I needed to get it from you.
I have a separate objection to the questions in ground one, which is that they cover questions that had already been asked.
Sorry, which are we talking about?
Part two, should I say?
Part two, yeah.
Part two questions also reflect questions that have already been answered by Commodore Dory.
Okay.
And there is no basis established by the appellants to go behind that advice.
Okay.
Now, that may not matter in relation to part two because we're both agreed that you should not ask those questions. Well, we are both agreed that they're not appropriate for this court to ask.
Yeah.
So far as the part one questions are concerned, although in an effort to be helpful to the court, we have worked on the wording, it remains our submission that those questions should also not be asked because they go to matters not only that we say have already been determined by the trial judge, but also because they raise the same issues that have already been put to the nautical assessor at first instance. See Annex 2 of the judgment, questions 6, 11, 14 to 16, and 17C. Sorry, and 17 rather than just 17C, which he has answered.
Yeah.
And so, my lords, unless there is an issue on which your lordships feel separately that you would be assisted by seeking advice from the assessors, in which case, of course, we will assist in framing the questions.
Yeah.
My submission is that while we've done our best to agree a wording, should you consider it appropriate to ask the questions, it isn't appropriate to ask them for the reasons I've outlined,
Yeah.
and given the guidance of the House of Lords in the Savina.
There's no part 3.
Not that I've seen, my lord.
No. I mean, emanating from you. There's
No,
nothing.
there's no separate.
No, fine. All right. Well,
my position, perhaps unsurprisingly, is that the advice that was needed was provided at Commodore by Commodore.
no, I get that. It's just getting it right.
My
That's
lord, of
all
course.
all I'm interested in doing. So I understand the position of the appellant, and now I understand the position of the respondent.
I will just add this, my lord, that obviously we remain to assist the tribunal, the court. So if in your discussions post today there comes a matter on which you want assistance from us on questions, then we will of course address that as and when it arises.
Right,
My
thank you
lord,
very
unless I
much.
can help any further.
No, thank you very much, Mr. Cooper. Yes, Mr. Smith, is there anything in reply?
My lord, there is, if I just give me a moment to rearrange. Can I start just by dealing with those questions? Because, of course, my lords had them, but not heard us on them. My learned friend, Mr. Carruth, will deal with part 1. But on part 2, the only reason we put questions in that list as potential questions is because we understood my learned friend to be saying that you could rely on the answer that Commodore Dory had given to similar questions. My understanding of what he said this afternoon is that those questions aren't appropriate, full stop. So on that basis, we don't urge those questions any longer.
I thought that was your position anyway.
My lord,
I thought you thought it was inappropriate for us
because
to
they're
ask the
matters of
assessors.
construction.
Yes.
But I had understood my learned friend to be saying that one could, in certain circumstances, look to the answers that Commodore Dory gave, in which case we would have said that we do impugn those and you need to look at them again. But in the light
That would
of
then
what
be
he's...
repeating the same questions and falling foul of the Savina.
Well, my lord, I don't need to go there because of what my learned friend has said.
Well, no. You may not, but I need to get it right. So, as far as the questions are concerned, you don't urge part 2 on us because you say it's a matter of construction. Yeah, understand that.
So, my lord, and Mr. Carruth will deal with part 1. My lords, I will be as quick as I can by way of reply, but there are some points I need to deal with. And the first is in relation to the additional finding of fact that we invite this court to make in relation to the visibility of the sidelights of AFINA I. And I, with respect, struggled at one stage to follow what my learned friend was saying about that, because he started his submissions by saying, quote, that the learned judge had considered in his reasoning the fact that KIVELI could only see a green sidelight. So I put a big tick in my notes and thought, well, he's agreed with us that she could only see a green sidelight. And he then went on to make some submissions saying that you shouldn't make the finding that we urge. My lords, 2 points. Firstly, he said that the judge's conclusion was based on the advice of Commodore Dory. So far as I'm aware, Commodore Dory didn't deal with this point at all, whether the red sidelight would have been visible as well as the green sidelight. Secondly, he didn't demur from the main point that I made, which was on the agreed factual evidence and absent any yawing, there was no question in our submission, but that KIVELI could only ever see the green side light. And I said to my lords yesterday, of course, that the learned judge concluded, but by C-16 we could only see the green side light. There was no rational basis in our respectful submission for him not to make the same finding at C-22. The second point, by way of reply, is also a factual point. My learned friend yesterday, and he repeated it to say, said that it was never the view of our Office of the Watch that this was a crossing situation. And he submitted that we were, in effect, trying to wriggle our way out of the position as he understood it to be. And he went so far as to say that he believed it was a head-on situation. My lords, we accept, and the learned judge concluded, that based on the evidence the chief officer gave in cross-examination, that he believed the Cape Natalie was in a head-on situation. But he never accepted that in relation to AFINA I. He was adamant in his cross-examination that he could only see one sideline, that it was a crossing situation, and that he believed he was seeing the masthead lights. The phrase he used was diagonally. Obviously, we don't have that evidence, but I'm responding to the point my learned friend made orally. But what we do have is Commodore Dory's record of the evidence. And he said, we don't need to turn it up, but it's core bundle page 252. The chief officer of KIVELI, in his statement, only ever concluded that AFINA I was a crossing vessel. So the suggestion my learned friend made yesterday and today, that we always thought this was not a crossing situation, we're just trying to get out of liability, is with respect not correct.
So which, on page 252, which is
It's the very first line of answer 11. I apologise, my lord, I should have been...
answer 11, yeah.
And skipping on, taking the 14C point slightly out of turn, if I may, because it follows on from that. That point illustrates in our respectful submission why we must be right on 14C. Because if our Office of the Watch considers it's a crossing situation, how can 14C compel him to turn to starboard? My learned friend's point in his submissions yesterday and today were essentially that if it was close enough to be in doubt, we should have been in doubt too. That, with respect, is a different point. That's saying we're negligent for thinking it was a crossing situation. That's a different point to saying that 14.2 operated on the day to oblige us to turn to starboard. And he said today that there was nothing in Rule 14C that says that only one vessel is required to turn to starboard. With respect, that's wrong. 14C is drafted by reference to the vessel in doubt and specifically says that she, that's the vessel in doubt, must turn to starboard. It does not impose an obligation on the vessel that is not in doubt. So that's why we say we are right on the 14C point. I'm not going to say anything else about that. Having taken those points out of turn, going back, if I may, to my learned friend's starting point yesterday, his what one might call big picture points. He submitted to my lords that it was necessary for the rules to be construed in a way that could be easily understood by seafarers around the world, professional and amateur, and we agree with all of that. The difference between us is that in our submission, it is our construction that complies with that requirement, not his. And he said yesterday that everything we were saying was all very complex because one had to look at the travo, one had to look at all the cases, one had to look at 3 degrees, 6 degrees, all the different plots we've looked at. And how could a mariner on the bridge ever be expected to do that? With respect, he was eliding 2 different points. One is the task that we have as lawyers after the events of seeking to establish the proper construction of the rule. The other is the application of the rule by the mariner on the watch on the day. And our construction, we submit, is a simple test that fulfills all the requirements of the Supreme Court, especially at paragraph 141, the fundamental construction of the rules, that they need to be applied by reference to what is reasonably apparent to those navigating each vessel about the conduct of the other. And our construction involves looking ahead and to both sides, observing where the other vessel is, and observing what aspect of her you can see. At night time, when the side lights are within range, that is a very easy test to apply. And my Lord, Lord Justice Nugee raised a point as the ability to take a bearing, and I should have mentioned when I responded to that yesterday, I think that my learned friend did say that, of course, the Supreme Court in the Eversmart mentioned, it's paragraph 52, the last 4 lines, that one could always take a relatively accurate bearing with a compass with reasonable precision, is the phrase the Supreme Court used on the basis of advice from their assessors. Now, I accept that our test becomes a little more nuanced if you're at night and you're within the range of the masthead lights, but not the side lights. But equally, any test based on lights will be more nuanced during the day. What you are looking for is the corresponding aspect or angle, to use the French text. And we do say that that test is far easier to apply, brings with it greater certainty and greater safety than a test that depends on one's subjective understanding of the word nearer used 3 times within the rules. Essentially, yes, it is necessary in the 2 nuanced situations to perhaps think more carefully or assess the position over a longer period of time than you would do if you're just in this paradigm sidelight situation. But our test is still the one that most usefully performs the function identified by the Supreme Court. And we accept that it won't give a clear answer in every case. My learned friend said today that our construction didn't take into account the vagrancies of the sea, the waves, the wind, other factors that may, as he discussed with the court this morning, cause one or perhaps both vessels to yaw. That is why Rule 14C is there if either vessel is in doubt. But they're still obliged by their other obligations under the rules to use all available means to keep a good lookout and observe the other vessel and assess the risk of collision. So we agree that yawing, as I think was put to my learned friend this morning, might increase the 3-degree arc, but that's the job of 14C to deal with that. And we do, in the light of the submissions my learned friend made this morning, invite my lords to consider this point. If there was an officer of the watch, for example, who had read what Farrell said at page 389 of the bundle that I took my lords to yesterday, and proceeding on the basis that reciprocal meant up to 5 or 6 degrees, then on my learned friend's case, that officer of the watch was negligent for doing so, because he says it can mean more than that. And on the learned judge's case, it can mean 6 degrees, perhaps we don't know how much more, slightly more, he says. That, with respect, is of no use to the mariner. The same would be true of an officer of the watch who'd read Cockcroft and the extracts I referred to at page 407, not engaged when you can only see one sideline. The same with an officer of the watch who agreed with Captain Thornton's view about masthead lights and when they should be treated as being in line or nearly in line. And my lord, the other flaw of my learned friend's approach, and this is the position whether we're right on any of the subgrounds, the definitional issue or anything else, is that the advice the learned judge had from his assessor when he asked about what was or was not reciprocal or near reciprocal was that the reciprocals during the relevant period, which included up to 7.3 degrees, were within a reasonable tolerance of being reciprocal or nearly reciprocal. And that, with respect, was not good enough. The learned judge said, well, he must have meant reciprocal or nearly reciprocal, but the advice Commodore Dorey gave was that those reciprocals were within a reasonable tolerance. And so all we have is uncertainty, whereas our submission as to construction leads to certainty. Another point my learned friend made this morning, which I need to deal with, he said, I think more than once, but certainly once, that one of the flaws with our approach is that it requires the officer of the watch on one vessel to put himself, as it were, into the shoes of the officer of the watch on the other vessel and work out what the other vessel was seeing. And in our submission, that's a bad point. And it's a bad point for the reason I debated, I think, with my Lord Justice Foxton yesterday. On our construction, you look at the location of the other vessel and the aspect. So is she ahead or nearly ahead? Are you seeing both sidelines? And if that tells you that it is a head-on situation, then as a matter of geometry, the officer of the watch on the other vessel will reach the same conclusion. And that's why my learned friend is wrong to say that our test requires KIVELI's officer of the watch or AFINA I's to know what is in the mind of the other officer. And in one sense, that is also the answer to the and or and the of vessel question. Because that symmetry, that reciprocity in the geometry is what means that neither the a vessel or the and or questions are on my critical path, because they become packaged up if we're right on
They become what, sorry?
packaged up with everything else if we're right. So if I'm right about the overall definitional issue, then it's inherent within that, which is no doubt why Sir Nigel's focused on reciprocity. It's inherent within that if the right location and the right aspect is observed by one vessel, the other vessel will reach the same conclusion. My learned friend on that point said this morning that when he was dealing with the structure of the rules, that there was nothing in the rules that requires the observing vessel to be within the 6-degree arc. And obviously I accept nowhere in the rules does it describe a 6-degree arc by use of the word 6 degrees, but it is necessarily built into the requirement to see both sidelines. That is a 6-degree arc, 3 degrees either side of the centre line, which equates to a difference of 6 degrees between the reciprocals of the vessels.
If the side lights are 3 degrees.
If the side lights are 3 degrees. And my lord, I accept...
So it's not built in. It's consistent with if the side lights are at 3 degrees.
My lord, I accept that. But as I said yesterday, that's why it's important that both officers of the watch are still maintaining a good lookout by all available means and looking at everything else. But it's still, we submit, is part of the definition that defines the head-on situation. And he said this morning that our construction overlooked the fact that Rule 13 and 14 take priority over Rule 15 and 16 and 17 by making something that would be a head-on situation, a crossing situation. With respect, that submission assumes he's right on everything else, because on our submission all it does is confirm that something that is not a head-on situation is not a head-on situation. Dealing with the ever smart, he relied on the fact that the paragraphs I rely on all come under the heading context and purpose. But in our submission, that's a point that supports us. As I said yesterday, the Supreme Court is dealing with all steady bearing cases and saying that they must fall within one or other of the rules. And that was the approach the Supreme Court was taking. And he repeatedly emphasised that they were not dealing with Rule 14. But it was such a fundamental part of their analysis that all Part 2 cases, all steady bearing cases, would be within one of the rules. It in our submission, defies credibility to think that the Supreme Court did not have in mind the consequences of what it was saying about Article 14, Rule 14 and Rule 13 having precise triggers in subparagraph B in both cases.
Would you accept this, that on Rule 14 and the interplay between 14A, 14B and 14C, let alone coming on to Rule 15, there has been no case before yesterday and today where the points have been argued to this degree of, to use your word, nuance?
My lord, absolutely. And I have to accept that the Supreme Court was not addressed on all the consequences
No,
of what it said.
which is plainly why this case is important, because it's certainly, speaking entirely for myself, it seems clear that there has been no case which has looked at these points in this detail and with this degree of, if I may say so, on the ball advocacy as this case yesterday and today. So that's certainly, again, speaking for myself, something which I have very much in mind.
My lord, I see the force of that point entirely, and in that respect, I was going to move on to mention the Lot Vivek, and all I was going to say about that is that the points my learned friend makes were correct. They don't meet the point I was making, which was that there was no need for Mr. Justice Clerk to pose the both sidelines question or ask his assessors about the both sidelines question if he didn't believe it was relevant. My lords, the next point I wanted to deal with was my learned friends in relation to the Travo. He said you cannot be certain that you've seen all of the Travo. That is obviously correct. I certainly haven't. I'm sure my learned friend hasn't, but we've both, I'm sure, seen a lot more than the court has seen. I certainly have read a lot more than the court has seen. But we do say that there is sufficient in the material that you do have to reach conclusions as to what the intention was. And we say that primarily because the convention was the product of the drafting committee and a subcommittee of the IMO, and then went forward to the International Conference for approval. So it was drafted at the IMO, and the papers you have are the IMO papers, and a lot of the material we rely on is notes from the Secretariat, so summarising, as it were, or might call it the mood of the meeting. And we say you can take away 3 points from the Travo, irrespective of what my learned friend said. The first is that every single specific reference to Rule 18, and there are quite a number of them, I'm not going to go back through them, indicates a clear and unanimous intention to shorten and simplify the text, to improve it by clarifying difficult terms, but to maintain the same principle. And that principle, we say, is that the obligation on both vessels to turn to starboard is triggered by the relative location of the vessels, because that principle provides the most simple and clear analysis of any situation. And that was the wording of the Soviet delegation. I should say,
No
now
wonder
that we
you
do
get that from the words of 14A. I mean, that doesn't add.
I would guess. We do accept that part of the reason for the changes to Rule 18, as my learned friend said, I hope this is helpful, was to close the lacuna caused by the fact that Rule 18 specifically said it's not head-on if you're definitely going to miss each other, because you might be definitely going to miss each other by 10 metres, and that clearly isn't safe. So we accept that part of the reasoning was that, but that's equally consistent with our construction as his. My learned friend did say, sorry, that second point from the Travo is, however, that there is nothing in the Travo that you've been shown or that either party has been able to locate to indicate that there's an intention to widen the scope of the rule, other than to cover that lacuna and to insert 14C to cover the cases of doubt. In terms of widening the principle of when there is a head-on situation, nothing to suggest that that was the intention. And the third point we say you can take from the Travo is that the wording, slightly amended, as the Secretariat pointed out, of what became 14B was regarded by A, the delegation that drafted it, the USSR, as a defining provision, and B, by the Secretariat as a defining provision, because you'll recall I took you to the page where they referred to there being definitions in what became Rule 13 and Rule 14.
Mr. Smith, can I ask this about the Travo? Your 6-degree, 3-degree figures stem from provisions set out in that part of the collision regulations addressing side lights and where they must be visible, which don't appear to have equivalents in the 1960 regulations as far as I can tell. But, obviously we don't have any travo discussing the selection of the 1 to 3, still less that in selecting those, what was had in mind was some knock-on effect on operation of rules 13 and 14. Has anyone had a look, or is it simply there isn't any discussion in that sidelights travo?
My lord, I have certainly had a look at the travo relating to the rules, the core rules for sidelines. We have had a look for the travo relating to Annex 1, where the 3 degree are, and not being able to find anything. And within the travo relating to the visibility of lights, there was quite a lot of debate about the relative visibility of lights between the side lights, the masthead lights. There was a lot of debate about different coloured lights. There was a lot of debate about a lot of things, but none of which seemed to me to be pertinent to the question.
Well, I'm grateful for the effort.
Well, my lord, it's important because it's only having reviewed everything.
Attention, please. Attention, please. This is the Incident Control Officer. A report has been received of a Attention, please. Attention, please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer.
That is likely to be repeated.
Attention, please. Attention, please. This is the Incident Control Officer. A report has been received of a suspected fire in the main building. This is being investigated by the security fire team. All fire evacuation and first aid officers to alert status. Please stand by for a further announcement and obey the instructions of your local evacuation officer.
Mr. Smith, we'll carry on. We may well get interrupted again, in which case I will then rise until they've sorted it out. Yeah, okay, so those are the 3 points that we take from the travo.
My lord, yes. And finally, just to deal with one point my learned friend made yesterday, he did give one example yesterday where he said it looked as if the rules were trying to widen the scope, and that was the greater latitude to the stand-on vessel that he took my lords to. And I think my Lord Justice Foxton put it to him that it was clear that that was intending to be in a different context. Just for my lord's note, if one turns on to a couple of pages to page 286, it is clear that that was a reference to including what is now Rule 17A2 to permit the stand-on vessel to take action. So my Lord Justice Foxton was correct. My lords, on the could-would point, I have, having stood up this morning to I hope assist, have nothing else to say in relation to that, apart from, no, I did cover that this morning. So the next point I want to look at, no, I've dealt with that, course and heading, which there was some debate with my learned friend. The Supreme Court dealt with that at paragraphs 48 and following. We don't need to turn it up, my lords have already looked at it. And they said that what mattered was course over the ground. But that was, as they said, for present purposes. And in our submission, it's important to bear in mind that the present purpose, you have this at page 85, is the questions that the Supreme Court were being asked to consider. They expressly pointed out that, of course, the crossing rule doesn't use the word course anywhere. They were considering course because they were looking at the course of the vessel that was on an erratic course, never came onto a clear course, across the entrance to the narrow channel. And what was important was that Alexandra I was moving over the ground what was important for the Supreme Court's analysis is that therefore this was a steady bearing case, because
You do get 2 references to course in Rule 17.
yes, but sorry, my lord, yes, but not course in the context that we're talking about it, which is for Rule 14 point. Sorry, what I should have said, my lord, is the Supreme Court said Rule 15 doesn't refer to course. I was skipping on a little bit too quickly. But the important point is that they were considering course because the question they were asked to consider was whether are the crossing rules only applicable when the putative gives way vessel is on a steady course. That is the context in which they were considering course, not in the context of Rule 14A. And so the Supreme Court don't, with respect, tell us what Rule 14A means by course. And in our submission, it must mean, as Captain Hurst said, and we looked at the little drawing yesterday at Authorities 22.438, it's equivalent to heading, not course over the ground, because it's the heading that the vessels look at to determine the relative aspect of the other vessels. He said that would be what would be regarded by most mariners and marine lawyers as a crossing situation. That's the situation he drew in the sketch, and we would respectfully agree. My lords, next period of application, so this is ground 2. There's little that I need to add to what I say yesterday, other than response to my learned friend saying it's not clear why we say it has ceased to be a head-on situation, to ask my lords to look at the plots at Core 156 and Core 168, and then to just have a look at ground 2, where we set out what it is about the relative location of the vessels that mean that they have passed out of the head-on phase. I use the word passed out of because that's what Viscount Finlay used in the Orduna. We don't disagree with any of what my learned friend said about the Orduna, but the key issue there was when the vessel turned to starboard, the green sidelights of the other vessel were still ahead of her. She was still in the crossing phase. And my learned friend said it had to be crossing or head-on because of what the Supreme Court said. And with respect, that's not correct. Supreme Court were saying that all steady bearing situations had to be either overtaking, crossing, or ahead. And the point we make after C-745 is that this was no longer a steady bearing case. My learned friend is right. He took my lords this morning to the bearing between the vessels at C-22, and indeed a little bit before C-22, and a little bit after. And it was a steady bearing from one ship to the other. And that's why we don't challenge the judge's conclusion. There is a risk of collision at C-22. But what happened afterwards is that AFINA I went from being fine on our starboard bow to ahead to fine on our port bow, and then starboard bow, wrong way round. Fine on our port bow to ahead to fine on our starboard bow. And by the time we get to C-745, the time we say that the rule ceased to apply, it wasn't a steady bearing case. And that's why you no longer have to say it's one or the other or the other. And that's why we say, my learned friend said he wasn't clear what we say it was. I'll make it clear. It was not a crossing situation after it ceased to be a head-on situation. It was a situation of two vessels that are still in uncomfortably close proximity, and therefore they're obliged to follow the rules of Rule 2, good seamanship, to take action if necessary to avoid a collision, and to keep a good lookout, all the other rules in Part 1, but it is not a Rule 14 situation. And he made the submission today, or this afternoon, that the situation did not change as a consequence of their turn to starboard. With respect, he's misapprehended our case. We do not say that it ceased to be head-on because of AFINA I's turn to starboard. We say it ceased to be a head-on situation once she'd passed out of being head-on, once she'd passed out of being within the arc of visibility of our sidelights, so that none of the requirements of the definitional part of Rule 14.2 were any longer in play. And so in our submission, that is why the rule ceased to apply on that C-745. Just quickly then, if I can, what my learned friend said about the various authorities. He took my lords to Farrell, first of all. As with most of these authorities, there's good and bad for both of us. And I would just remind my lords of the passage at the foot of page 389, where that I took my lords to yesterday, where Farrell essentially agreed.
Well, if you've taken us to it, we'll have a note of it, and we don't need to be reminded again.
Marsden, my learned friend said the new edition refers to the judgment with approval. I accept that the footnote he took my lords to does, but the rest of it is really just reciting what the judgment says. And in relation to the footnote, all they're really saying is, well, the judge interpreted what we said in the last edition. His interpretation was correct. It really doesn't take us very much further. And he didn't refer, my lords, to Cockcroft. I won't go back to that because I've made my point about that. And as to the articles written by Captain Hurst and Captain Thornton, I addressed those extensively yesterday. Yeah. And I don't propose to say anything else about them today. Towards the end of his submissions, my learned friend referred to and relied on the answers when he was dealing with our specific grounds of appeal that Commodore Dorey gave as to his answers 2, 3, 8, 10 and 11, submitting that we didn't have permission and needed permission to appeal from those findings, essentially to make good our case on the definitional issue, the and/or issue, and the vessel issue. I've already dealt with why neither the and/or a vessel issue are on our critical path, but I only make 3 points in response to what he said. He said that the answers were essentially admissible because Commodore Dorey was dealing with questions of how the rules would be applied rather than matters of construction. We would respectfully submit that is something of dancing on a pinhead in these situations because one needs to construe the rules before one can decide how how they apply. Secondly, the answers he referred to and seemed to be relying on today are not any of the answers from Commodore Dorey that he refers to in his skeleton, so it's not entirely clear to us the purpose for which he relies on them. But looking at those questions, and if I could just ask my lords to have those open in the core bundle, divider 8. First of all, question 2, at page 245. The question was, bearing in mind the agreed statement of facts and the information contained therein, as the extent you consider it relevant, the information, the lights contained in the table, in your view, were the vessels on reciprocal or nearly reciprocal courses at any of the following times? And there are 2 issues we have with that. First of all, essentially, the judge is asking for the nautical assessor's view on a question which is for the judge. But secondly, that presupposes what the answer is as to the proper construction of the rule. And so if we are right as to the proper...
Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing. Attention please. Attention please. This is the Incident Control Officer. The emergency condition has been resolved. The building is declared safe. All personnel may return to normal duties. All key emergency staff, please report to the main hall for debriefing.
We got away with that. So firstly you say matter for judge, and secondly you say it presupposes what the construction is.
What proper construction is. And that essentially is my answer to all of the points my learned friend took. The reason why we don't specifically say, and Commodore Dorey got this wrong in our grounds of appeal, is because our grounds of appeal are predicated upon the judge's construction being wrong. And if his construction is wrong and our construction is right, then one has to apply our construction rather than ask the nautical assessor. And that essentially comes right back to where I started with my lord as to why we say the questions are inadmissible. If you ask the right questions as a matter of construction, these answers my learned friend is relying on don't take the matter any further. Although I should say that goes for questions 2, 3 and 8 that he listed. But in case it assists my lords, there's very little that we disagree with in the question 10, because that is a different point, the risk of collision when it arose. And so, my lord, just finally, my learned friend Mr. Carruth will deal with question 11. And then the last point my learned friend made, or not the last point he made, but the last I want to respond to, is he said we didn't challenge the finding of fact that both side lights, sorry, not both side lights, both masthead lights were seen in a line or nearly in a line. That's not correct, because of course we do challenge the judge's conclusion on that. What we don't challenge is the nautical assessor's own view about that, but again it comes back to the construction point. If we're right as a matter of construction, that should be defined by reference to the same 3-degree arc.
But that, the finding about the mastheads being, the lights being in a line or nearly in a line, that's a finding of fact.
Well, my lord, in our submission, no, because it presupposes what is meant by nearly in a line.
You're saying if it means 3 degrees, then by definition it's wrong. But I think you accept that if it doesn't have a geometric meaning, but it requires an answer to be given in a specific case, that answer has been given. Let's just say that it's the words are nearly in a line, and that force to be applied by the judge. He's reached his decision, hasn't he?
If I am wrong on everything else, including the importance of the side lights and everything else, because of course our case is that if you can only see one side light, you can't see them in a line. But subject to all those caveats, that if I'm wrong on everything else, then the answer has been given.
Yeah.
And the same answer is true for the points my learned friend made about paragraphs 1.5, 1.6 and 1.7 of our notice of appeal. I don't need to repeat myself. And unless I can assist further, Mr. Carruth will have a little to say about apportionment.
No, thank you very much, that's very efficient. Yes, Mr. Carruth.
My Lords, I have 4 points. Point 1 relates to the question of whether we lack the necessary permission to challenge the judge's views on apportionment if it was a crossing situation.
Yeah.
I took you yesterday to the grounds of appeal and
Yeah.
skeleton argument in support of permission application. I'm not going to go back to that. The thing I didn't take you to yesterday was Lord Justice Popplewell's order granting permission. I'm sure your lordships have read it. I don't ask you to turn it up, but I'll just read the relevant sentence. Apportionment of liability may be effected should the appellant succeed on grounds 1 to 3.
Yeah.
That is what Lord Justice Popplewell said, having read our grounds and skeleton argument in support. I say that is all the permission we need. The only other thing I'd say on this topic is that the civil procedure rules and the Court of Appeal guide do require grounds of appeal to be as concise as possible and not to duplicate the submissions in the skeleton argument.
Yeah.
Point 2 relates to whether this court should interfere with the apportionment of the judge below. My learned friend says you shouldn't because of the difficulties associated with doing that. I say that in fact those difficulties are not very great at all once the true scope of our challenge to the judge's views, if I can put it that way, is understood. And I just want to illustrate that, if I may, by reference to a handful of paragraphs of the judgment. If I could ask your lordships to turn up core bundle page 237. And this really is the page that contains what we consider to be the offending paragraphs. That is to say, the judge's analysis of rules 15 to 17. Just starting with 313, you'll see he says on KIVELI's case, she was the stand-on vessel. As such, she had an obligation to keep her course and speed, rule 17A1. This she failed to do, and he talks about the nibbles to port, and then he says she did not keep her course and speed, but instead turned hard to port, which was precisely what she should not have done. That turn, i.e. the turn hard to port at C-120, was a breach of Rule 17A1 and Rule 17C. Well, 2 points there. It can't be a breach of Rule 17A1. On any view by C-120, we are entitled to take action under 17A2, putting aside the question.
May. This is the May.
It's the May point. So it can't be a breach of Rule 17A1. The second point, the turn to port at C-120 can't be a breach of Rule 17C either. Rule 17C says that action taken under 17A2 should not involve a vessel turning to port, the stand-on vessel turning to port for a vessel on her own port side. But by C-120, or at C-120, AFINA I was not on her port side, she was on her starboard side. That is illustrated by position 8 attached to our skeleton argument. So both of those points are wrong. And if I could just ask the court to compare it with what is said at paragraph 250, which is on page 221. And you'll see there, starting from the third sentence, however, as will appear, his actions were not even consistent with what he should have done if it had been a crossing situation. What he should have done at and from C-22 was turn to starboard. So in paragraph 313, the judge says that she was wrong not to hold her course at C-120, but at 250, he says she should have turned to starboard at and from C-22.
So that's an inconsistency point.
Yes.
Arising for the first time in your reply at the end of the second day of the appeal, which is not in the notice of appeal. To use an analogy from another case in a different form of transport, we are so dangerously close to island hopping, it's not true. You know, it can't be a proper way of asking us to decide these points. I mean, this is a point. You're saying that paragraph 250 and paragraph 313 are inconsistent.
Yes, my lord.
That would be a classic ground of appeal.
Well, two points on that, my lord. First of all I'm seeking to illustrate here is that actually the extent to which we disagree with what the judge said below is relatively narrow. It is
Well, that may be a matter for considerable debate. I mean, I understand the point, but and I don't want to stop your submissions, but speaking personally, they may lead me to conclude that if all the other dominoes fall the right way, the last thing we should be doing would be ourselves getting involved in the apportionment.
Well, I appreciate this a question, my lord, as to whether this court should get involved in apportionment. My current submission is you ought not to be deterred from doing so by a submission that it would be incredibly difficult for you to do so because you haven't heard all the evidence. Really, the crux of our complaint...
I'm not worried about that. I'm more worried about the fact that you're making points to which the respondent has not had an opportunity to respond.
I take that point, my lord, and I'll move on. I think I've made the point in relation to this paragraph. I hear what you're saying, my lord.
That's because I'm saying it loud and clear.
Indeed you are, my lord. But really, just the fundamental point was our complaint about the judge's approach below a crossing situation is confined to the paragraphs on that page and his analysis of the crossing rules, which I say, if you read them with care, is clearly wrong. The point I made yesterday, it reverses the obligations of the two vessels, the giveaway vessel and the stand-on vessel, and one can see that very clearly from paragraph 316.
Does it come to this, that if the AFINA one is meant to keep out the way, the breaches as against the KIVELI in that scenario are premised upon failing to take action to respond to the failure of the AFINA one to do what she's meant to do, then they benefit, as it were, from a more charitable treatment within the overall apportionment regime than if they are original faults, if I can put it that way, rather than failure to respond to someone else's non-compliance.
Yes, my lord, I think that's a fair way of putting it. If I could just at that point deal with the part one draft questions to the nautical assessors, my lord. If you have those.
Yeah.
You'll see there are only 3 questions we invite your lordships to ask the assessors in relation to apportionment. Sorry, 4. No, 3. And tying in with what I've just said, these relate to primarily.
Hang on.
Sorry, my lord.
I've carefully filed this because it came with. Yeah. Okay. Well, we've read this. Certainly,
Yes, so tying in with what I just said, my lord, these questions relate primarily to the correct approach, the correct analysis under Rule 17. For example, the first question is about whether we were obliged to take action as a matter of seamanship prior to Rule 17b being engaged. That is, of course, because the judge's view, as I've just showed you, was that we were obliged to take action as and from C-22, which we say is wrong. We say that's wrong in the permission skeleton at paragraphs 70.3 and 73.5, so we say we have impugned that and the question should be asked. Question 1b, when, if at all, should KIVELI have taken action under Rule 17b and what action, if any, should she have taken? Well, that's the question about when Rule 17b was engaged. You'll have seen our case on that. I think I covered it yesterday, and it's in our skeleton. We say it's in the very last moments before collision. Commodore Dory did not actually put a time on it. He said that KIVELI was obliged to comply with Rule 17b, but didn't precisely specify in answer 11 when, in his view, that was. So we say it's permissible to ask that question because it hasn't actually been addressed but answered by the assessor below, and in any event our case on it was set out in the permission skeleton at paragraph 73.7. And then question 1c, this is about AFINA I's turn to starboard at C-515, which was criticised by Commodore Dory in the court below. He criticised it as being a late or not made in ample time and being a stilted turn.
That's so the 20%.
Well, it could be, my lord. It's.
I mean that you said rightly that was criticised, and my understanding is that's the principal reason for the 20% apportionment.
Well, it's not possible to know with certainty what went into that 20%, my lord. You may well be right.
Yeah. Okay.
So those are the part 1 questions and why we say those are appropriate questions to ask.
What about 2?
Oh, sorry, my lord. Yes, of course. Question 2.
I mean, you said there were only 3 questions.
Yes.
On any view of the maths, which I'm not, there I counted 5 separate questions there.
You're quite right, my lord. There are many more than 3. I'd missed question 2 or forgotten about it. This is all about ground 2. So this is all about if we lose on grounds 1 and 3, but we succeed on ground 2, as in it was originally a head-on situation that ceased to be one at C-745. What is the appropriate apportionment then? That was not considered at all, for obvious reasons, in the court below. Commodore Dory expressed no views on it, so it would not be asking the assessors in this court to answer anything which Commodore Dory has already answered. Point.
So just so my note is clear, question that the 3 sub-questions within 1 are if you're successful on grounds 1 and 3, and 2 is if you're successful on ground 2.
Yes, my lord.
So although question 1 has an ABC1, it doesn't have an ABC2.
That is correct, my lord. The formatting could be more elegant, certainly.
For which I take sole responsibility.
Further or other relief? always stick in.
Point three, my lord, just on the 20%, and this ties in with my learned friend's submission that, well, essentially that 80-20 would be the correct, or at least close to the correct apportionment, even if it were a crossing situation. I just thought I'd point out to your lordships that Captain Hurst's published view is that AFINA I was, quote, very fortunate to get away with 20%, even on the basis that it was a head-on situation. That's in the authorities bundle, tab 22. Page 427. As I say it even more strongly, if it's a crossing situation, it can't be 80-20. Final
That's
point.
what happens when you're a judge. People don't offer you the help. You do the apportionment, you say 18-20, everybody criticises you.
Indeed, my lord.
It's comes with the territory.
I think he says there that there will be a further article about it. I don't think we have it. There wasn't one. Was there?
As far as I'm aware, there have only been two, the two that are in the bundle.
Waiting
They're
for
not.
the judgment from this court.
I'm told there are three. My learned friend has the advantage of me there.
Captain Hurst wrote 2 articles before the Hill Dickinson article on the travaux. One was dealing with the application of Rule 14, and one was dealing with the views on apportionment, his views on apportionment. You have the article, I think, in the bundle that deals with Rule 14. He didn't at the time consider it necessary to trouble the court with Captain Hurst's views on apportionment.
Final
They're
point.
clearly trenchant. Yes.
Yes, final point, my lords. If you are minded to remit on the topic of trenchant views, I'm sure the court will appreciate that those on my side of the room have some concerns about the trenchant views that were expressed in the consequentials judgment as to the appropriate apportionment if it had been a crossing situation. All I would say is this is an unusual case where the case was not tried by the Admiralty judge, and therefore there might be an alternative way forward which would involve remission to the Admiralty court, but not necessarily to the trial judge, and that's all I'll say.
To hear the evidence all over again
No, my lord, to hear to consider the issue of apportionment.
on the basis of the findings of fact.
Yes, my lord.
Mr. Justice Brown.
Yes, my lord. On this hypothesis, it would be your lordship's view as to the fact that it was a crossing situation, or cease to be head-on at C minus 745, and with the assistance of assessors, if your lordships have decided not to ask questions in this court, or at least up to the judge whether he considered himself to be assisted by further guidance from the assessors. Unless I can assist you further, my lords, that's everything I was going to say.
No. Well. Oh, sorry.
I do apologise.
That's right.
But the submission that the case, if remitted, ought not to go back to Mr. Justice Bryan has, of course, only been raised by way of reply. That is the first we had heard of that suggestion. It has the obvious difficulties that my Lord Nugee already identified. We would also say that it has the obvious difficulty that whoever it is would have to effectively start again and does not have the bank of knowledge that Mr. Justice Bryan has. And while he may have expressed firm views in his consequential judgment, he is, of course, a judge of this court, of the High Court, and there is no reason to believe that if asked to consider the matter again on remission of the views of this court before him, he would not do so properly. There is no reason to put the parties to the additional cost and expense of going to a different judge, should we ever get to
I was going to say, if the dominoes fall that way, then that's clearly something that we'll decide. Mr. Cooper, since you've got to your feet, can I just ask you, just to make sure that everything is covered, I pointed out to Mr. Carruth that he was making submissions, in particular in relation to the correlation between 250 and 313 of the judge's judgment, that those were inconsistent, which were new, which he graciously accepted. Is that something that you can point me to where you dealt with it, or is it something you want to deal with, or are you content to rest on what you've said?
But my lord, I didn't specifically deal with that point because, as your lordship rightly pointed out, it came by way of reply.
Well, I follow.
I haven't considered the point immediately as to whether or not there is an obvious answer. What I will say is that it's always invidious to take two paragraphs of a very lengthy judgment out of turn and to suggest that there are necessarily inconsistencies. We say that certainly for the purposes of determining whether or not on apportionment the judge was right to arrive at 80-20, or at least that is not an apportionment that this court should interfere with, then one has to look at the judgment as a whole.
Yes. Well, perhaps to cut it short, perhaps the best thing would be this, since it's a new point and the submissions have been very clearly made. What I would propose is that if there was any response on that specific point alone,
any response would be confined to.
If you wanted to put in something of no more than 2 or 3 pages, if there was a response that you want to put in, and I'm not, as it were, requiring you to, but if on instructions you wanted to, then provided that was with us sometime middle of next week, then I would allow that, because it's a new point and I would be anxious to ensure that we had heard from both parties on all points.
I'm grateful for the permission, my lord. I'll consider the transcript.
So if we said 5 p.m. next Wednesday, if you wanted to, or if you decided not to, that you notify us and the appellant before that.
My lord, of course. Yes.
Right, fine. Okay. Right, well, thank you all very much. Thank you to the 3 of you and the teams behind you. As I indicated to Mr. Smith, it is plain, it has been plain for a while, that this is an important case. You'll be unsurprised, therefore, to learn that we're not about to embark on extempore judgments. We will reserve our judgments, and you will get them when they are concluded, but that may be a bit of time because we're in the middle of a term, and we will want to consider the submissions very carefully. As you both know, I'm required to say this publicly, you will get drafts of our judgments. That's an opportunity for you to comment on our grammar and typographical errors. It's not an opportunity to re-argue the case. The draft will be sent to counsel, the instructing solicitor, and anyone who has been notified, the name and contact detail which have been notified to my clerk, but that has to be kept to a minimum because the drafts are confidential, and it is a contempt of court for them to be referred to, much less published. Once we've had your responses, and at the same time as you're considering them, if it's possible for you to agree an order reflecting the result in the draft judgments, then all to the good. If you can't agree it, but you can agree most of it, and then there are 2 or 3 bits you disagree on, the best thing to do is to provide us with a coloured version with your different versions in different colours, so we can see what the points are, together with very short written submissions, and we will deal with those, and then the final order can be agreed either at the time that the judgment is handed down or shortly after. There will be no need to attend for the handing down because that's now all remote. So I don't think there's anything else, but except to repeat my thanks to all of you and to the 2 nautical assessors for making themselves available at such short notice. Thank you very much.
All right, the table.